Students, and welcome to Political Science 1513, American Federal Government. As always, I am your instructor, Connor Alford, and in this video we're going to begin our discussion of natural rights, both positive and negative. This is the first half of lecture for this week, and the second video, which will come sometime before the end of day Monday, will provide you with some lecture on the particular civil liberties protected in our Constitution. Before we can get there, however, I wanted to upload this video so that you had an opportunity to familiarize yourself with some key concepts, some important vocabulary, and some key historical principles. So let's go ahead and get started by looking at the learning objectives for this video, understanding that another lecture will subsequently follow with its own set of equally important learning objectives. The first learning objective for this video asks for you to explain what a natural right is and where natural rights come from. The second learning objective asks for you to define, explain, and distinguish between civil rights and civil liberties. You should be able to identify examples of each and to identify the synonyms associated with each of these terms. The third learning objective asks for you to describe the two main historical trends in the development of legal protections for civil rights and civil liberties here in the United States. And then finally, learning objective number 4 asks for you to explain how the United States Constitution and the United States Supreme Court, on the one hand, are related to our civil rights and civil liberties on the other hand. So let's go ahead and get started by talking about natural rights. A natural right is an inalienable right innate to human nature. In other words, these are the rights enjoyed by all members of the human family simply by virtue of being human. Understand that natural rights are protected legally by the Constitution, but that they are not created by the Constitution. Natural rights come from your nature as a human being. All humans, regardless of where they live and whether they're under the jurisdiction of the Constitution, enjoy the same basic natural rights. So, if you are a living organism and you are a member of the species Homo sapiens, you have a fundamental right to life, liberty, and the pursuit of happiness, period. This is true without condition or qualification of any kind. Every member of the human family is equally entitled to the same basic rights. That idea of the natural right, an individual, inalienable liberty, universal to all members of the human family, is really going to be introduced to European political thought in the 17th century by the writings of a number of political philosophers, but in particular by the writings of a British philosopher named John Locke. And John Locke is quite frequently considered an intellectual founder or an honorary framer of the United States government, because our Declaration of Independence, our United States Constitution, our Bill of Rights, all of these foundational documents and many of the core values that define American political life are going to derive from ideas that John Locke either introduced or at least popularized in Europe. And these same principles are going to become the foundation for all Western society in the modern world, but especially for the United States. So, for example, I want you to understand, John Locke's political philosophy basically said that a just political order was one in which the government was based upon the consent of the governed, not a divine right to rule, not the right of might, but by the consent of the governed. And that once a government was instituted by the consent of the governed, you could judge whether that government was just and should be upheld or unjust and should be overthrown by asking yourself whether it respected the natural rights of its citizens. If the government respects, protects, and promotes the natural rights of those that it governs, then it's a good and just government which ought to be upheld. But if it does not respect them, then it is an unjust government and it ought to be overthrown. So the idea of natural rights, introduced to the founding fathers of the United States by John Locke and his writings, is going to be a very significant one for a number of reasons. Number one, these rights are seen as universal. They are innate to every single human, and that's very equalizing. So first, they're universal. Second, they're equal. Doesn't matter whether you're the king or queen or a peasant. You could be a rich landowner or you can be a tenant farmer. You can be an American or you can be a Saudi Arabian. It doesn't matter. We all have the same equal rights. They are universal and they're equal, which challenges social order as it had been established in Europe up to this point. But other than uprooting the traditions, customs, and expectations of political order in Europe during the late medieval and early modern era, these ideas are also important for a number of other reasons. See, once we say that they're universal and equal, we now have a transcultural, transhistorical standard against which to judge and limit all governments. The third reason why natural rights are so significant is that they become a tool for limiting and judging governments. When I tell you that you have a freedom of speech, I create a rule that government has to follow. It cannot censor your speech. It cannot violate that freedom of speech. So our natural rights create moral limitations on what governments can and cannot do. I also want you to understand that natural rights are individual rights. They're not group rights. They're not women's rights or men's rights. They're not white rights or black rights. They're not American rights or Canadian rights. They are individual rights. Each individual human organism possesses the same set of natural rights. So a particular person, Bob, Rashawn, Lisa, or Mary, Tamara, or Maria, or Miriam, all of these individual people have rights. But groups of people do not have rights. And that's an innate part of Western civilization today. This is a part of what we call the liberal democratic model of government. And it all comes back to the writings of John Locke and the American Revolution and the Declaration of Independence and the Constitution. So they're universal, they are equal, and they are individual. These are all important characteristics. They are standards that we can use to judge whether a government is just or unjust. But I want you to understand that they're not always respected. Okay, so we all have natural rights, but that doesn't mean that our governments are going to protect them. And this is where the Constitution enters into the discussion. Because in the United States, the Constitution is where we look to find the legal protections for our civil rights and our civil liberties, which are each going to be a subcategory within the broader category of natural rights. So I do want you to understand a civil right and a civil liberty are each going to be a type of natural right protected in the United States Constitution. The United States Constitution protects our natural rights through a set of legal guarantees. There are two types of guarantees that you need to be familiar with. First, we have guarantees about what the government cannot do to us. These preserve our civil liberties. Then we have a set of guarantees about what the government must do for us. These protect our civil rights. So what are civil rights and what are civil liberties? A civil liberty is a natural right protecting individuals from government action by securing certain individual freedoms that governments are prohibited from taking away. I want you to understand that civil liberties necessarily create prohibitions against government action, and the existence of these prohibitions is designed to secure basic freedoms. The idea here is that every individual is entitled to some basic liberty. That basic liberty encompasses your right to be the master of your own life, your own body, and the fruits of your own labor. And what we're going to discover is that in order to continue being the master of your own rights, your own life, your own liberty, so on and so forth, you need a basic degree of freedom. If the government starts taking away your freedoms, then at some point it becomes the master of your life. So civil liberties are preserved by the Constitution in the interest of promoting freedom. And they are preserved in the Constitution through a series of guarantees about what the government cannot do to us, because civil liberties are protections against government intrusion or infringement of freedom. Civil rights, by contrast, are natural rights involving goods or services that we are actively entitled to receive from the government, independent of our willingness or ability to pay for them or acquire them on our own. And where our civil liberties are protected by prohibitions against government action in order to ensure some degree of freedom, civil rights are going to create mandates for government action. They're going to be protected by guarantees about what the government must do for us in the interest of promoting equality of opportunity. So, for example, you have a civil liberty to free speech. That means that you are allowed to speak your mind, and that if you choose to do so, the government shouldn't interfere. But it doesn't mean that the government has to give you a megaphone or pay for the television advertisement you want to run. On the other hand, you have a positive right to an attorney if you're ever brought to a court of criminal law. If you're charged with a crime, you will receive an attorney. If you cannot afford one, one will be provided to you. So the government must actively provide you with legal counsel. Why do we protect the freedom of speech? Well, because we recognize that government can become tyrannical, that it can enslave people if we're not allowed to call it out when it starts doing things like violating our rights. So again, that freedom of speech, protected in our Constitution, is about securing basic freedoms. But why do we want to protect your right to an attorney, even if you're unwilling or unable to pay for one on your own? Well, because what we're going to discover is that if we didn't provide attorneys to those who could not afford them, there would be some fairly substantial inequalities in the criminal justice system. People who could afford attorneys would get them, and therefore they would have some positive legal outcomes. Whereas people who could not afford attorneys would have to argue their own cases, which never works, and so there would be a lot of negative outcomes for the poor. We would have a great deal of inequality among these different groups of individuals. We don't want that, so to ensure that a poor individual has the same opportunity to receive a fair trial as a rich individual, we're going to say that attorneys, legal counsel, that's a civil right. Whereas when we're talking about speech, when we're talking about religion, that's a civil liberty. The government doesn't have to help you practice your religion, it just doesn't prohibit you or prevent you from doing so. Maybe another way to think about it is to say that you have a negative right to be an attorney. You have a positive right to receive an attorney if charged with a crime. And this is where I can introduce you to some of the important synonyms for each of these key terms. Civil rights are sometimes called entitlements or positive rights. We call them entitlements because they involve goods or services that we are entitled to receive from the government. We call them positive rights because they create a positive obligation, an obligation on the government to engage in some affirmative action to actively provide us with some good or service. In the United States, this good or service usually manifests itself in the form of government protection from unequal treatment on the basis of our race, gender, or disability status. But in addition to civil rights or entitlements or positive rights, we also have what are sometimes called negative rights, freedoms, or civil liberties. Civil liberties are called freedoms because, again, they are individual freedoms that we are entitled to enjoy without government interference. They are called negative rights, however, because they create a negative duty, a duty of not acting, a duty of non-interference, a duty of inaction. In other words, remember, civil liberties tell us what the government cannot do to us. It cannot censor our speech. It cannot force us to practice a certain religion or prohibit us from practicing another religion. These are going to be distinct concepts, but I do want you to remember that civil rights and civil liberties are both subcategories within the broader category of natural rights. And for this reason, I sometimes prefer the language of positive rights versus negative rights to the language of civil rights and civil liberties. The fact that civil liberties are a type of natural right can get sometimes confusing, because what it means is that when we look at the Constitution, some of the things which are called rights are actually civil liberties. They are natural rights, but they are civil liberties. For instance, the Second Amendment protects the ability of an individual to keep and bear arms. This is a negative right. This is a civil liberty, not a civil right, even though the word right is explicitly used in the text of the Second Amendment. How do we know that the Second Amendment protects a negative right? Well, remember, negative rights tell us what the government shall not do. And what does the Second Amendment say? The right of the people to keep and bear arms shall not be infringed. In other words, when the Constitution says that you have an individual liberty, a right to keep and bear arms, it means that you are allowed to own a firearm if you are able to purchase one on your own. It does not mean that the government has to supply every citizen with a Glock. If it were a positive right, that's exactly what the government would have to do. It would have to actively provide you with that good, the firearm. But when we're talking about the Second Amendment, understand that it's a natural right, it's a negative right, but it is a civil liberty. It is a freedom that you may choose to practice if you would like to do so, but one which you cannot compel others to take part in. That's not the same as your right to an attorney. Now, I do also want you to understand that throughout history, the way we look at our natural rights and the types of legal protections they receive have changed in the United States. There have been two major historical developments in legal protections for civil rights and civil liberties that I want you to focus on. The first major historical trend has been a gradual transition from our early emphasis on civil liberties to our current emphasis on civil rights. In other words, we've gone from an early focus on freedom to a modern focus on entitlements for the purpose of equality. If, for example, you were to look at the first 10 amendments to the United States Constitution, what we call the Bill of Rights, but what we ought to call the Bill of Liberties, you're going to find that pretty much every right it secures is a negative right. The freedom of speech is a negative right. The freedom of religion is a negative right. The right to bear arms is a negative right. Your freedom from warrantless searches and seizures is also a negative right. It tells us that the government ought not subject you, your physical person, or your effects to a warrantless search or seizure. These are going to be prohibitions on government action. The government shall not censor us. The government shall not take over the press. It shall not force people to practice certain religions. It shall not conduct warrantless searches and seizures. It shall not subject people to cruel and unusual punishment. Nowhere in here are we seeing examples of active goods or services that the government must provide. And that's because the concept of a positive right didn't exist at the time that the Constitution was written. When people talked about the rights of man at the time that our Constitution was written, they meant negative rights. All natural rights were originally understood to be freedoms or civil liberties that the individual was entitled to enjoy without government interference. But that really began to change. And it didn't begin to change until after the United States Civil War. See, before the Civil War, we had this case of Barron versus Baltimore. And actually, I'm sorry, I'm getting sidetracked. Ignore that. Before the Civil War, we had freedoms. After the Civil War, we get a series of 3 amendments. Amendment 13, Amendment 14, and Amendment 15. And what we're going to discover is that Amendment 13 abolishes slavery. Amendment 15 prohibits racial discrimination and voting laws. But Amendment 14 is much more comprehensive. So it's going to do a few things. Number one, it redefines citizenship to encompass newly emancipated African Americans and their descendants. In other words, it says that you cannot deny somebody citizenship because they used to be a slave or because they descend from somebody who used to be a slave. That's not okay after the 14th Amendment. The 14th Amendment also includes the Equal Protection Clause, which we will talk about momentarily, and it includes the Due Process Clause, which we will also elaborate on momentarily. For now, just note that the Equal Protection Clause says that no state shall deny its citizens the equal protection of the law on the grounds that they used to be a slave or descended from somebody who did. In other words, what this is telling us is that states probably shouldn't be discriminating against their citizens on the basis of skin color. And that's going to become important for the purposes of civil rights in the United States constitutional legal system. Because in the early 1900s, that 14th Amendment Equal Protection Clause is going to be reinterpreted. And it's going to be reinterpreted to create the foundation for all civil rights in our country, what we call the Equal Protection Doctrine. And the Equal Protection Doctrine basically says that it's not enough for the government to say, I will not discriminate against people. It must actively intervene when other groups are doing so. So, for instance, if a state discriminates against you on the basis of your skin color, it's the federal government's obligation to come in and enforce that Equal Protection Clause against that state. And that seems pretty straightforward, but what if it's your employer who has discriminated against you? Well, when the 14th Amendment was originally written, it wasn't understood to apply to those private actors. It was understood to apply only to the government. But it will be reinterpreted by the courts starting in the early 1900s to create an affirmative obligation to tell the federal government that it must actively protect people from unequal treatment. So the 14th Amendment, as interpreted by the Supreme Court starting in the early 1900s and continuing till today, is going to initiate a transition from our early emphasis on civil liberties to a modern emphasis on civil rights. It used to be that the courts focused almost entirely on protecting individual freedoms. And they still do that to some extent, but they're less concerned with freedom and more concerned with equality in most cases today, because they're focusing on our civil rights, the positive duties of government, the active goods or services that the government must provide to a much greater extent than on the individual freedoms that the government must not violate. That's a stark contrast with the national environment and discussion when our Constitution was being written. So we've gone from an early emphasis on negative rights to a contemporary emphasis on positive rights. That's the first major historical change. The second major historical development has been a gradual incorporation of our rights and liberties against the states. And here is where we can start to talk about Barron versus Baltimore. Because in this case, the United States Supreme Court told us that the Bill of Rights, the liberties protected in our Constitution, provided protection from violation by the federal government, but that they did not apply to the states. So, for example, the First Amendment clearly says that Congress shall make no law respecting an establishment of religion. Essentially, that means that the federal government cannot force you to practice a particular belief system. It cannot have an official church of the United States, for instance. But you might be surprised to learn that a large number of states, in fact, the majority of states, did have state religions, did have state churches. And there were laws on the books which did things like required people to attend church regularly or to baptize their children. None of this would fly today, so obviously something has changed. Like, imagine that Oklahoma decided tomorrow that we were officially a Baptist state and that everyone had to convert to the Baptist religion and everyone had to get a Baptist baptism of their children. We wouldn't accept that. Would have been accepted at the time of Barron versus Baltimore. So what happened? Well, first off, remember that when the Constitution was written, it was a charter of federal government. So the Bill of Rights, an amendment to that charter of federal government, was in fact intended to apply only to the federal government. It was creating limits on what the federal government could do, because people had this understanding that states could more or less be trusted to look out for the best interest of their citizens as long as those states were democratic. Slavery and the Jim Crow laws, which came after the Civil War, proved that that was wrong. So this is where we're going to look to that incorporation doctrine under the second bullet point on this PowerPoint slide. The incorporation doctrine is a doctrine which the courts are going to use to gradually apply the Bill of Rights against the states, and they're going to rely on the 14th Amendment to do this. Remember that 14th Amendment tells us that states shall not deny equal protection, that states shall not deny due process on the basis of skin color. And what that means is that all of a sudden, there is room to argue that there are at least some constitutional limits on what states are allowed to do found in our Bill of Rights. And that's exactly what the courts are going to do. They are going to interpret the 14th Amendment as incorporating certain portions of the Constitution against the states. In particular, they're going to focus on the Due Process Clause, which says that states should not deprive people of life, liberty, or property without due process of law. And they're going to say that the term due process in this clause is broad enough to encompass any of the substantive rights in our Bill of Rights. Now, they're not explicit, and it takes a long time because they do this gradually. They do it one piece at a time. First, they say, yeah, the free speech is a part of due process. Later on, they're going to say that so is the freedom of religion. And more recently, they're going to say so is the Second Amendment's right to keep and bear arms. But little by little, piece by piece, virtually every single piece of the Bill of Rights has been incorporated against the states by the courts using the Due Process Clause to create the incorporation doctrine via the 14th Amendment. So those are the two trends. We've gone from focusing on negative rights or freedoms to positive rights and equality. We've gone from a series of limits on federal action to a series of limits on federal and state action. One final point before we close this video. Remember what I've already told you. The Constitution does not, in any way, shape, or form, create our natural rights. It does, however, provide the protections for our natural rights. These rights that are protected are what we call civil rights and civil liberties. Remember that it protects our civil liberties by giving us guarantees about what the government cannot do to us or take away from us, and it creates protections for our civil rights through guarantees about what the government must do for us. But here's the key point. It doesn't create those rights, it just protects those. And I also want you to understand that the Constitution only protects our rights, our freedoms, in very general terms. For example, the Constitution tells us that we have a freedom of speech. But it doesn't tell us what all that freedom of speech encompasses. One way to interpret the freedom of speech would be to say that it only applies to literal verbal articulation. But if that were true, then say a deaf person who communicated with sign language probably wouldn't have the ability to express themselves. They wouldn't have that legally protected freedom. And you wouldn't have the freedom to express yourself by making posts on Facebook. There's nothing in the Constitution that explicitly says you're allowed to criticize the president on Facebook. And yet, if the government tried to criminalize you for posting an offensive meme, well, you would probably be upset, and rightfully so, and you would probably try to challenge that law in a court of law, rightfully so, and here's the thing, you would win. Because what we know is that the freedom of speech is broad enough to encompass literal verbal communication, but that it also encompasses a whole bunch of other forms of expressive conduct, including making posts on Facebook, or expressing yourself in writing, or expressing yourself through the clothes that you wear. You're allowed, for example, to put on a pin that says vote for candidate X. And if the government tried to prohibit that, well, it would get in trouble. So where do we get this idea that the Constitution's big picture, general principle, we should have free speech, protects our ability to make posts on Facebook, or put bumper stickers on our car, or wear political paraphernalia? Well, that's going to come from the Supreme Court. The Constitution relates to our civil rights and civil liberties, and that it codifies them into law and provides them with general protections. But if you want to figure out how those general protections apply to particular cases, you've got to look to the courts. The Supreme Court in particular has a special role in constitutional law. It interprets the general principles of the Constitution and helps us to resolve disputes about how those apply to particular cases or controversies. If a group of students show up to school wearing anti-war armbands and they're expelled, has their freedom of speech been violated? Well, we know they have a freedom of speech because the Constitution says so, but we don't know if it's been violated. To figure that out, we look to the Supreme Court, and the answer here turns out to be yes. The Supreme Court told us in Tinker versus Des Moines that the freedom of speech is broad enough to encompass a student's ability to wear an anti-war armband, and therefore public schools ought not expel them for expressing themselves in this way. So again, what we're going to find is that our rights come from our nature as humans, but they are protected in general terms by the Constitution, and in particular cases by Supreme Court interpretations of the Constitution. And that's more or less what we need to know about the big picture. So remember the difference between civil rights and civil liberties. Understand the concept of natural rights, what they are and why they're significant. Understand how the legal protections for these have evolved over time and why. And understand how our civil rights and civil liberties are related first to the Constitution and second to the Supreme Court. Then, once you've satisfied all these learning objectives, you can progress to the next component in this week's lecture. I'll see you on the next one.